I think we can have a better approach than that. And when you look at a contract, whether it's a small subcontract or a large multi-million dollar contract, you should approach it with some sort of theoretical approach so that what you're doing is planned and systematized. The other aspect these days is that we're trying to make whatever we're doing amenable to users of all experience and competency. So therefore, in the old days when you might have a very experienced person able to run contract management, that was satisfactory. But these days you've got to be able to provide a system that works for more new entrants. New entrants are coming into the industry all the time, and the system needs to be robust and simple and clear enough that those new users can use it as well. The other aspect at the bottom of contract administration as its objective is to reduce waste. The construction industry has an enormous capacity to generate waste. If you have a situation, say, you might have a latent condition, it has enormous potential to have waste, that is, economic resources devoted for no particular benefit to anyone. If the contractor says, well, I don't have to pay for this latent condition, so I'll just spend what I like on it. And the principal says, well, I won't have to pay for it, so I don't care what he spends. You can see the potential for huge amounts of waste in that system, because somebody eventually will end up paying for it, and it won't have been a cooperative, collaborative attempt to produce a result with maximum efficiency. So they're the three sort of objectives that I would say should motivate you to look at contract management in a bit of a different light and with a different objective. So the situation now I want to do is to try and go through the slides, and we'll start off. Hopefully you can see all those slides at that stage. Coming up is the contract administration title slide. So if you go through to there, we say the role of contract administration in construction, it ensures project success. The reality when you sign a construction contract of any size or complexity as a principal or a contractor is you're effectively bound together with the other party in an awkward and sometimes ugly sense of a partnership. Fundamentally, if projects go smoothly and they're well administered and well performed, then everybody makes a profit out of it. And that's why the construction industry attracts so many participants. But if it goes off the situation, then you'll find that there are awkward aspects that creep into it. So the project success is an ultimate aim. You've got some key functions where you've got to track performance against contracts, and you've got to handle claims and variations and changes that occur during any normal construction contract. And you've got to document and record the basis for decisions. Again, one of the characteristics of construction, which is a constant concern of regulatory authorities, but also all participants, is its capacity for corruption. So therefore, if you happen to have given a great big sweet variation to your second cousin, if somebody comes to argue about that later, you will need to be able to justify it. So documenting changes, finding proper justification for payments made and arrangements struck is a very important part of contract administration. The other aspect, of course, is that construction is increasingly highly regulated, from environmental to safety to the standard of materials you use and the standard of construction that you achieve. There's massive regulations. Again, if you do your job properly and if the work is done well, you don't have a problem. But of course, if there's any foul up, then legal and regulatory requirements will be a pressing problem. they'll also be a sort of a career-threatening move if you have allowed, say, as the representative of a main contractor, a subcontractor to get away with unsatisfactory work that sometimes works for a couple of years, but then, for instance, leaks everywhere. So if as a principal contractor, you let somebody who's contracted to provide waterproof planter boxes to provide a lick and a promise instead, then it's likely to come back and be attributed to you with a great amount of personal pain. The risks of poor administration are clear. That is, missed deadlines, cost overruns, litigation, claims, and miscommunications among the stakeholders. And if you've looked at any of the recent wind-ups of contracting companies, you'll see that the potential for things getting out of control in construction are particularly present. And when contracting companies particularly are wound up, there's very little left in the pot to be split among the creditors, other than perhaps the banks who've got security and perhaps external assets under mortgage. So the situation then is, there's a bit of a quote from Sir Anthony Mason, who said construction administration is very important. The other aspect is one has to look at the basis of contract administration. And I've listed there the three sort of main elements, and that is the contract itself. You must be happy to read a contract and pleased to understand its clauses and how they interact, even if we have to deal with contracts that don't provide for every opportunity or circumstance that arises on a job. They can only do so much, and they're already fairly long and complex. The other aspect one has to look at these days is the Security of Payments Act, because the reality of life is that if there's a disagreement on a construction site, somebody's likely to go to the Security of Payments Act and put forward a claim. The aspect of that is twofold. One is that it may eventually arise in a judgment against the head contractor or principal, but more particularly, it will put some searching attention on the contract administration. So if somebody puts in a claim and shows that he has given clear and documented notice of a claim, or he has filled out all the notices and claims that he was required to under the contract, then if the principal hasn't responded to those in intelligent ways, it shows up pretty quickly. Again, the Security of Payments Act is a very documentary-driven act, and of course, if you don't administer the contract and document your administration, you can be exposed pretty badly in that forum. The other aspect is the common law principles, the general law. You've got all sorts of implied terms, good faith, reasonableness, and you've got a situation where there's a great body of law that will be relevant perhaps to any of the contract administration, but fundamentally you start with your contract and you're aware of the security of payments and the other common law litigation principles that will follow through. The question then is, how do we approach this little morass of trying to get order into the chaos of a building contract? This is my approach. My approach is that there's 4 points of contract administration that should be watched carefully. And these are 4, if you like, hold points or review points that should be looked at carefully and devised, preferably before you too far into the contract. One is a contract signing. So before you sign a contract, you should run through a review, a checklist, which we'll go into detail in subsequently, to identify the risks and the procedures that have got to be followed and the resources that have got to be mobilised, and to make sure that everything is in order. If you start right, you've got a chance of ending up properly. Thereafter, in most contracts, you've got the need for monthly reviews, and monthly reviews tie in neatly with progress claims in the usual course, and enable everybody to give attention to the contract administration as it proceeds. The driving force of that is the fact that from a subcontractor, he will be looking for a check, he'll be looking to be paid, and from a principal, he'll be looking to make sure that there's not too much paid and that what is paid is consistent with the performance and with the contract. Again, you've got two further checkpoints. The monthly reviews might go for a year or 2 years, each month going through the same checklist, making sure that everything is in order is what's required. At practical completion, you should be reviewing your handover requirements. That's when effectively the principal takes back the project, and therefore the construction in the great amount is completed, notwithstanding there might be some defects. So again, that calls for planning in front of it to bring it off nicely, and also a careful checklist to make sure that you've thought of everything that needs to be thought of. The other aspect with that is that usually there is a liquidated damages clause, which says that if you mess up your practical completion, that is, you can't supply something that's crucial for practical completion, then the situation is you're likely to pay liquidated damages for a substantial period of the delay. So it's important that we prepared for and we administer carefully the practical completion aspects. And then, of course, you've got final completion. Now, in lots of projects, particularly years ago, people would forget this. They just disappear. With a bit of luck, he got most of his retentions back, and that was the end of it. But it should be something that is planned, carried out carefully, and documented carefully in order that the contract is wrapped up and closed out. So they're the 4 points that I think you should look at to make sure that you're prepared for each of them and you're conducting each of them in an orderly way. We'll go through now the concepts that come up in respect of each of those whole points, because if we get them right, then the situation is the contract should be well administered. So the first one is the checklist before you sign up. And you can see why that's important, because you've satisfied all your precondition, you've tried to clarify any aspect about the work and how it's to be conducted, and you've reduced the risk of litigation by making sure that you start off at least on the right foot. It ensures compliance, so you'll need to confirm the key contractual clauses, ensure statutory and regulatory requirements, licensing, insurance approvals are met. So obviously you want to have those in place before you sign the contract. Again, one needs to understand that in the English or Australian tradition, signing a contract is a particularly important aspect. If you promise to sell a Melbourne Cup winner to somebody, then practically before you sign a contract to deliver that Melbourne Cup winner, you've got no responsibilities, and if the negotiation doesn't meet your expectation, you can walk away without any hassle. But 5 minutes after you sign a contract to deliver that horse, if you don't produce it, you're up for millions of dollars worth of damages. So it's a very important aspect, and you must make sure that you're in a position to discharge it before you sign the contract. Additionally, it identifies any ambiguities. Again, if before you sign a contract, you say, look, I just like to clarify some aspects of the access to the site and blah, blah, blah. The situation is that can save you a lot of hassle later on. And again, the general aspect would be to put something in the contract that records whatever access arrangements were agreed just before it was signed. So the other aspect is that lots of people say, well, I get contracts and I chat about them and nobody moves anywhere. Nobody wants to move on their clauses. In my view, that's still an important process. If you discuss the clauses that will give you concern with the other side, you've got a clearer view of their attitude to it and how tough they're going to be on those clauses, and you know clearly what you'll have to do to satisfy them. So it's important that you get a clear view of what they intend and you can assign resources and attention to it. The running over some of the key things that one would check before signing is the scope of works. It's a bit amazing that one can have a contract fully prepared, fully tendered, fully negotiated, but at the end of the day, there's some lack of clarity over the scope. So you might be paid, for instance, in a recent example, you might be paid for disposing of the spoil from the excavation, but it's a bit unclear as to why you're not paid for the excavation itself, because no one's thought about it, because no one's made a provision for it. Again, program and milestones is something to be checked, that you can actually provide the resources in the way that it should be provided. Risk allocation, is there anything in terms of liability caps that you need to provide for? So that, for instance, in respect to liquidated damages, you agree that liquidated damages will be limited to 1% of the contract price or something. Again, you check to make sure that, for example, something beyond your control, a war in Ukraine or a typhoon in Queensland, didn't destroy the essential imported component that you were responsible to deliver, and you had no protection from an open-ended liquidated damages clause running for the 6 months it takes to recover it. So that's important. Again, dispute resolution mechanisms, it's worth having a look at them to say what you're going to have to do if you have a dispute, and whether or not there's sensible provisions for resolving disputes quickly, and leaving then further dispute only to be resorted to if one or other party is unsatisfied. The benefit, for instance, of having a quick expert opinion on it, and before you go to more involved mediation and arbitration, sometimes can engender a common approach or a common enough approach to it so that the parties can resolve things and move on. Very important as well is time bars and notices. Are there any time bars in the contract? And as a contractor, you should be getting out an index to every clause in the contract and marking off all the time bars that are involved in it. We'll talk about it later as well, but the courts are probably over strict on time bars. And if you have to go the whole hard road of getting to litigation, your satisfaction of time bars will be very important. So again, for variations, for EOTs and for other claims, you'll need to be aware of what time bars and notices have to be provided. So walking through some of those, scope of works, defining deliverables, trying to work out whether there's any scope gap, lack of specification. Sometimes it's prudent to include inclusions expressly and exclusions. It's also important that you make sure those exclusions and inclusions are carefully drawn. If you say include all painting is included, for example, the question is, does that mean all the external painting that the parties were discussing, or does it mean all external and internal painting? So again, you're looking for those exclusions and inclusions to be as well specified as any other part of the specification. So being too short with some of those scope definitions are an important sort of room for disagreement later on. Program and milestones. Again, you want to know what you're doing in respect of it, and you want to have some program, whether or not it's contractually required. You want to have some program that you're working to yourself that allows you to program resources and also program inputs on the other side. And again, if you're able to do the ultimate, you'd have a target program, which is one that is more aggressive and one that you try and work to, and also a contract program. And be careful to make sure that one had applied in respect to the contract for all the extensions of time that are due to you, notwithstanding that you might be confident of eventually reaching the date for practical completion. The difficulty is sometimes some of the problems that might assail you later on might not give you an extension of time, and accordingly you should claim them all as you go and keep the extensions of time up to standard. Risk allocation, you check what risks are associated with your party, and also what risks and obligations are allocated to the other parties, so that you can make sure that they're kept up to scratch. Common sort of issues is indemnity clauses. You want to be very careful of them these days. They can have very unexpected consequences because they're often very vaguely expressed in wide terms and increasingly unfairly said to be operating immediately before any loss is actually suffered or paid out by the person that benefits from it. Some of the indemnity clauses will impose liabilities on another party. So it's important to look at the risks and make sure that they're fully covered in the contract to your satisfaction. Payment terms, it's important to make sure that the sometimes very detailed provisions that are required prior to payment are capable of practical discharge. So people might say, I want a stat deck from all your subbies, I want a stat deck from all your consultants, I want a stat deck from all your suppliers, etc., etc. Well, that might be easy to write, but if you've got to satisfy it, you ought to work out whether or not you can do so, and you must make sure that in your subcontracts you've provided that those documents should be provided to yourself. So again, looking at the payment terms is important. Again, of course, there's the commercial elements which are usually clear about how long you've got to wait for payment, and that's also obviously an issue that you've probably taken into account during the tender period. One further aspect about risks is insurance. Unless you check the insurance, then the problem is not having insurance is fairly fatal. Insurance requires sort of heavy premiums, but more particularly, if something happens, it's a life-threatening event. Recent example come across is somebody who didn't check the insurance of his subcontractors. An incident occurs and the subcontractors go quiet, don't answer phone calls, and don't provide any details of their insurance. That would have been avoided by a proper administration, which says, firstly, that your insurance arrangements must be clear at the time the contract or subcontract is signed, and further, that each progress payment should make sure that you've got the insurance details signed off. The other aspect, of course, is that you'll need to secure the assistance of a broker to review insurance, because the question of the ambit of the cover is very important. In particular, does it cover your subcontractors? So if the subcontractor messes up, does your insurer cover you against the loss that you might sustain? Now, that's a question that, yes, it'd be very pleasant to have it, because if the subcontractor forgets his insurance payment or otherwise blots his copybook with respect to insurance, he can create a liability of many hundreds of thousands on your responsibility, particularly in respect of a principal, because the contract is likely to prescribe that you're fully responsible for all of the performance of your subcontractors. So it's important that insurance is checked out. We talked of dispute resolution mechanisms and looked at the checking that needs to be done. So what I've got in mind is that you'll have a checklist. At the simplest example, there's a list of questions on Excel, and you will tick them off. Now, the situation is, of course, that for a small contract for 10 grand's worth of work, you probably won't have an extensive checklist. For a multi-million dollar project, you'll have numbers of pages of checklists that you'll have to go through, depending on the contract and the scope of work he's got. But the scenario, again, with dispute clauses is you want something that's quick and efficient, at least in a temporary way, and then a proper method of determining any major dispute that occurs. So key checks, particularly for a contractor, are there notification deadlines or time bars for variations in EOT claims? Are the time limits reasonable? Can you satisfy them? The issue of notifying a weather event within 2 days seems reasonable when you sign the contract, but in the hurly-burly of construction might be pretty impractical to achieve every time. So the idea of having reasonable time limits and providing that you can get the information from the site and are able to put that into a sensible notification should be looked at the start. If you can start, the situation is that you've got a chance of finishing. So it's a very important checklist at that stage. There's a case of Mann versus Peter Constructions, where the court's taken a bit of a dim view to satisfaction of not properly documented variations. They've tried to save the contractor to some extent, where they might have given him a quantum merit recovery, which is basically costs recovery, and the situation that might save you, but documenting a variation, getting it signed before it's actioned, making sure you comply with the provisions under the contract is the best way of getting paid. So that sets out what I say is a foundation of contract administration. And if you go through those checklists, you're going to be reasonably comfortable that the contract will proceed further without too many problems. But in order to keep a situation where it is on track, you'll need to have your monthly reviews. And you need to say, well, why are they essential? It's obviously you can solve problems before they escalate. In a month, if somebody's done a variation that hasn't been approved, then the situation is if he claims for it and it's rejected because of some reason, presumably there's not too much at stake and he could fix anything before the next month's claim goes in. It's important that you see this as an opportunity to check that everything's on track. So it's important to look at the monthly checklist with a view to achieving a confirmation that what has started well is continuing well. The review areas should go over progress claims and payments, insurance and licensing. Has somebody dropped his license during the period? Time bars and notice, and the supply chain management. That is, he's been paid in advance to provide, say, plumbing supplies, plumbing fixtures. If you paid in advance, has he secured it with a bank guarantee, or alternatively, have you taken some security interest in the plumbing fixture supply? The situation is it's now more convenient to provide security in personal goods, and it may well be necessary, depending on the amount, that you do that where you've paid substantial amounts or proposing to pay substantial amounts. So it's important each month to check these requirements. Additionally, the administration of claims and payments means that if it doesn't occur, you will drop into SOPA. So you've got to be careful that, first of all, when the progress claim is received as a principal and contractor, that you have dealt with it within a particularly pertinent time, and that's in general 2 weeks, 10 working days. The circumstance is that if you don't reply to a SOPA claim, then you're technically liable to pay the lot. So the circumstance is it's important to have processes in place that ensure that every claim made is answered within that time. The insurance and licensing we've talked over, time bars. The situation is you want to make sure that you've got some supporting documentation for monthly review. And importantly, it's a matter of getting proper reports from the contracting party. It's important to realise that if you send a boomerang from Sydney to New York, the person that carries it there will be able to give you a tracking device, and you'll be able to see each leg of the journey, where it is and how it's arrived there and when it's arrived there. That's for a very small expenditure. Progress claims, which can be usually in the tens and hundreds of thousands, oftentimes the reporting that goes with that is fairly scarce, and that's a situation which should be addressed. Most disputes are going to occur over a period of 1 or 2 months. If you have got some, before the dispute arises, some regular monthly reports that show the status of the work, that show that everything that has been done is in control, it's easier to limit and to resolve any claims that arise out of it. You'll need to look at the clauses in the AS21 contracts, progress claiming, extensions of time, variations, payment claims, and certification. So the situation is that you should be aware of those clauses and should tick off their provisions as to their satisfaction. So if you're required to put in a program which has a number of characteristics, you should make sure that those characteristics are met. You also need to watch, because the standards are fairly old. 2124 is 1992, and the situation is that usually those clauses are often heavily amended, so that you want to watch that your copy of the contract is the one that you use to find out. So this one is a case of CM Assets and John Holland, and the subcontractor delayed the work due to late access, gave notice of delay approximately 3 weeks after it first occurred, contrary to contractual requirements. The question was he entitled to claim? And the Supreme Court of Western Australia said no. On CMA's own case, the first notice it gave intention to apply for an extension of time is well outside the time prescribed. In my opinion, we're entitled to insist on strict contractual provision and deny liability for the delay. So the circumstance is for a subby who's working under that situation where he's lost the opportunity to claim for what might have been a substantial delay, it's a severe impact. But it's a salutary lesson to learn that complying with the time bar is essential, and it's often better to comply with it and have a wrong claim rather than no claim at all. The difference between a badly drawn claim and no claim is substantial. So you're better to get the best claim you can into gear within the time limit prescribed by the contract. The next situation is the practical completion, and practical completion is sort of easy on some jobs. If you're building a hay shed in the back of Burke, then handing it over to the farmer should be a piece of cake. However, if you're building a multi-storey casino complex with multiple accommodation units in that complex, then achieving practical completion is a serious task. The other aspect is that if you're dealing with, say, the casino contract, you want to make sure that there is a progressive nature to practical completion. That is, that you're not trying to sign it all off on the eventual practical completion day, that you signed off 90% of it by going around and signing it off by agreement as each section of the works has been concluded. The alternative gives a massive delay and is a massive risk if you've got serious liquidated damages. So practical completion is important. It triggers the end of the liability for liquidated damages. It stops the insurance, usually changes from the contractor to the principal, and the situation is it means that the contractor has demobilised from site, so his capacity to fix defects and other things is compromised. So it's important that you go through and prepare a checklist so as you can watch practical completion come into play and probably plan for it 1 or 2 months before it's there. These are some aspects which will need to be looked at: compliance and certification, handover documentation, security and retention, liquidated damages, extensions of time, final site cleans, subcontractor closeout, and the formal notice of practical completion. So they're all administrations that you look to as you go through it. Again, if the project is of a human scale, you would conduct a joint site inspection in order to identify anything that needed to be done. If it's a massive project, you'll need to have arranged inspections over the preceding 2 weeks at least. Compliance and certification requirements. The situation is that complying with all the requirements to get your certificates is important. And additionally, for contractors and principals, it's increasingly necessary to get progressive and then final certificates of the quality of the work in order that one can get occupancy certificates and the project can be put into practical operation and control. So it's important that those certificates are progressively advanced and then signed off at the end. The getting back of retentions is often important, and liquidated damages needs to be looked at. So again, these are more detailed slides of some of the things that should sort of attract you there. The other aspect is subcontractor closeout. So at the end of practical completion is probably the end of all your subcontractor accounts, and they should sort of be closed out at that time or very shortly thereafter. That is, that you actually take the time to make sure their work is up to standard, make sure they've complied with all the requirements, and administration, that you've got a final sort of close out with them, and that they've got arrangements in place to deal with any defects that arise, and you've got sort of arrangements that will coordinate that with your own rectification of any other defects. And of course, at the end, you have to give formal notice of practical completion, and you want to make sure that your formal notices are in full compliance with the contract. You don't want to sort of put in a qualified or conditional practical completion. There should be only accepted to practical completion those minor defects that you can justify the contract don't imperil the practical completion aspect. They put in a case of H&M Constructions and Golden Rain Development. That was a case where the Supreme Court, New South Wales, has said that the conditional certificate that had been issued by the superintendent, which was conditioned on a few things, that is, he said it's practically complete, provided you do this, provided you do that, provided you with this. The circumstances is all very interesting, but the judge said, well, that's not really a certificate at all. That's just, a note on the way. And the circumstance is that the judge said the certificate had to specify what, as at the date, the actual date of practical completion, and not what would have been practical complete if it had been, if the conditions had been later satisfied. So that impacted on liquidated damages. So again, a important aspect of getting things done correctly and having things ready for the practical completion as soon as they're available. Final completion follows much the same course, and because you've had possibly 6 months or a year since practical completion and you've fixed up all the defects, it sometimes has less stress to it than practical completion, but it should still receive your attention. And that is that you close out subcontractors, you close out the principal contract, the main contract, and make sure that everything is done documented and all the documents are recovered, and that copies of all the warranties you've got from manufacturers and suppliers, any particular deeds or arrangements you've got with your subcontractors as to perhaps longer warranty periods are all documented. So that's there's some lists in the slides as to what it is, but I wanted to talk about two other concepts that are inherent in good contract administration. And one is the principle of sign-offs. That is that in a perfect world, each element of the work would be looked at by the superintendent or person performing that role and the contractor, and would be signed off. And the situation is that you would actually have a form that said, well, Zone A, Part B of the air conditioning, for instance, is satisfactorily completed. People will have ticked off the necessary things that should go with completion, and everyone has signed it. Now, the sign-off is not probably going to prevent a principal or a head contractor coming back if there's a major defect, but it means that there is a process whereby people have agreed that on the information they had at that time, at least, the work was done and the work was satisfactory. Very important for subcontractors and contractors to work on a mentality that sign-offs are expected and recorded for all the work parts. If you do that, the circumstance is that you have a far more defendable position in later proceedings, if it goes that far, or disputes, that the work was done if it's been signed off. The other aspect is that there's a magic in getting sign-offs. That is, you can have people with a verbal agreement and it doesn't cut much mustard. Some people say a verbal agreement is worth the paper it's written on. The situation, therefore, is what you've got to do is to have a actual sign-off. Somebody stopped, looked at the form and signed it. And that means that it's so much more easier to prove in later discussions or litigation. The other aspect that's important in terms of the Australian environment is the question of notice. And that is that you should draw things to people's notice. If you can't, you might not be able to get a sign-off, but you might have a notice. And if you've given notice, it counts for you greatly if there's a dispute that arises. So say, for instance, you have to use an alternative manufacturer's glue on some of your installation. So you can't get the glue that was recommended or specified, but the situation, you've got another alternative one. Well, if you keep that to yourself, it's going to react against you fairly badly. If, on the other hand, you write a letter giving notice that you had to change the glue because there's a supply problem, you can't get it, and otherwise you'll have to do an extension of time and all sorts of things, then the circumstance is it will hold well to you if there's a later dispute, if somebody comes back and says, well, I don't like the glue. If they've had notice that you are going to apply that glue, it's a good step in the performance there. Now, it isn't as good as a formal sign-off or a deed of settlement, but it's better than a kick in the head, and you should look for it on many occasions. If you've got to change something, if you've got to be late with something, if you've got to amend something, make sure you've got notice. The other aspect is both in terms of notice and in terms of sign-offs. Yes, the classic one where you serve the notice or serve the sign-off and get a physical signature is probably still the best, but there's no substitute for an email which goes out and says, look, you know, I've got a variation to change the doors. You've told me to do this. It'll cost you $4,000 and I can get it done by Tuesday, etc. And the email comes back, okay to go, agreed, excellent, or whatever. Those emails are worth their weight in gold. The situation is you must look to them to document your administration of the contract. And the reason why they're so powerful is that they're coming from some person, which normally one would accept that if they come from Joe Blow sent them. The next aspect is they're in black and white, which is hugely beneficial, so that they're documented. Two, they can be quite elaborate. If you need to take a couple of more paragraphs to explain your position in an email, it's pretty easy to do. And the situation is they're timed and dated, so that if, in fact, in the fullness of time, you come to have a serious psychological argument with somebody, producing an email makes the conversation so much more practical and so much clearer. And again, the sequence of events is enormously important. If, for instance, you carry out a variation before the superintendent tells you to do it, then you're exposed. If you carry out a variation after he told you to do it, then, you know, by comparison, you're on fairly solid ground. Again, the timing of that email is clear and discreet. And if you've confirmed it, and if you've told him that you've started it, and those advices come later, then you have the makings of a fairly straightforward case. So emails and documenting things is important. It's important, of course, not necessarily to document the matter on the basis that you're looking to rush off to the High Court instantly. But on the other hand, reasonably properly conducted emails are the great answer to administration of contracts in the construction industry.